Welcome to Harvest to Pour, the business of beverages, with your host, Matthew Shipp. This is the podcast for all of those who are involved in the agriculture all the way to the distribution of beverages. And now your host, Matthew Shipp.
All right. Hello and welcome to Harvest to Pour. I'm your host, Matthew Shipp. And today I am here with James Gourley, intellectual property attorney of Carson's, Allen & Gourley. They offer both legal and technical insight needed for ideas to prosper. James, welcome to the show.
Thanks for having me.
All right. So I'd like to start, just have you tell us a little bit about yourself. How'd you get into this intellectual property law? What's brought you to it? What's interested, and where are you now with it?
Yeah, so I'm an intellectual property attorney. I deal mostly with patents, trademarks, and copyrights, sort of some ancillary IP issues like, trade secrets, non-disclosure agreements, all that kind of stuff. But primarily I do patents, trademarks, and copyrights. I got into it because my undergraduate degree is in chemical engineering. And when I wasn't super excited about the types of jobs that chemical engineers do, whenever I graduated from college, I just decided to go to law school and pursue a career as a lawyer, because in order to help people get patents at the USPTO, you have to have a hard science degree. So I was kind of uniquely qualified for that. So that's kind of the path I took. And I've been doing intellectual property law since I graduated from law school in 2005. So quite a bit of experience.
All right. So what experiences do you have in the beverage industry as far as working with some IP and any good stories around those?
Yeah. So one of the first clients that I represented, the firm that I started with out of law school, represented PepsiCo, and they own Frito-Lay, Gatorade, Tropicana, Quake Race, and the PepsiCo bottling, obviously. So I did a ton of patent work to them over the years, and much of it, related to the beverage industry. And I also know more about how to make potato chips than most people could ever imagine. But a lot of the innovation around the beverage industry involves packaging. So different sort of designs for a bottle or a can, different ways of making the bottle or the can, ways to do it more efficiently, use less material, make it more attractive, all that kind of stuff. They're always thinking about those kinds of issues when they're trying to improve the way they do things. So that was kind of a lot of the patent work that I did for PepsiCo.
And what within that industry, what are some of the kind of challenges in IP that you run up against with, we'll start with beverages right now, then we'll go with the size of the business later. But what are some of the unique challenges you've run into?
So a big deal for large companies is the amount of material that they use. I mean, that was one of the big, if a company like PepsiCo can make the bottle just even a tiny bit thinner and still have it perform, they could save, millions of tons of plastic,
Wow.
So they're always looking for these little things that will save them, tons of money and save a bunch of, raw material waste, all that kind of thing. So that was one of the biggies that they were always trying to innovate around. What's in the bottle or in the can, there's, it's mostly like kind of sugar and some flavorings, there's not really a whole lot on the patent side that you can do there, because it's pretty straightforward, what's going on. But yeah, the packaging was kind of the biggie in the beverage industry.
So it's the packaging and what looks like. Yeah, I've been talking to some others about packaging, and especially in now the up and coming THC Beverage Market, and their packaging is unique because they're having to change it every 5 minutes based on what the state regulations are at the moment, not the federal regulations. So one of the smarter ones I talked to, they own the vertical of the packaging because they can stop production, change the label because the state made a new decision. How does that? When you have something ever changing, does an IP cover that because it's the design or the system has to change?
Yeah, so that's more on the kind of the regulatory side, and I totally get that. I mean, there are all kinds of regulations on what information can be on the label, what information has to be on the label, and yeah, especially with cannabis because there aren't really any federal regulations.
Mm-hmm.
I've done a fair amount of work in the cannabis industry too, actually, but they you have to comply with each individual state's laws. So if you have if you're making packaging that you're going to use in California, it may not work in Colorado, or so those are all kinds of issues. And the way that may come up is, one of the most important pieces of IP in the beverage industry is the brand or the trademark. I think that's far more important than patents for the vast majority of beverage companies. So because when you're selling the product, you're building goodwill behind that brand. So when people go into a store and they see the product on the shelf, they immediately recognize it as your product. They know the quality of the product. They know, what sort of flavors, other characteristics are available, and they can find it quickly and make their decision based on what they already know, based on the goodwill that you built up in that brand. So that's what I've seen from my smaller beverage clients is the trademark and the brand and the look and feel of the package. That's just right underneath the quality of the product inside the package as the primary, driver of sales.
And that's what you want to put under the umbrella of the IP.
Yeah, trademarks is another
Trademarks.
huge area of IP that I've been practicing.
So what would you, I may suggest a little bit, but what would you suggest for a new, smaller company, the beverage industry or any other industry, as they're getting started? When do they really need to start concerning themselves with IP, their intellectual property, protecting it, and the law?
Well, the first thing, if somebody's thinking about launching a new brand, you really need to do a trademark search and see if there's anybody out there that's using anything confusingly similar. Big companies, we didn't do trademark work really for PepsiCo, but I know they've been involved in several trademark infringement lawsuits over the last few years, sometimes on the plaintiff side, sometimes on the defense side. Like the most recent one was PepsiCo launched a product called Gatorade Rise, which I think had caffeine in it maybe. And there was a company called Rise Coffee. Rise Brewing. I think they sold a Rise branded coffee, and they sued PepsiCo for trademark infringement. PepsiCo ended up winning, but it went on for like 2 or 3 years, and it was probably very expensive to defend it. So if they if they'd identified that issue earlier on, it would have been easier to resolve it earlier on rather than, drag out this trademark infringement lawsuit over the course of several years. But the huge beverage brand Diageo, they've had several brands involved in trademark infringement lawsuits, but a lot of this stuff can be sorted out ahead of time because you can do common law searches and see if there's anybody out there using a similar brand. You can search the database of trademarks that are registered at the U.S. Patent and Trademark Office and see if there's anything that's similar that somebody might complain about, if you launch this competing beverage brand. And you can sort out those issues ahead of time. And then, once you're comfortable that the trademark is available and you can use it, then you can file a trademark application with the U.S. Patent and Trademark Office and, secure the exclusive right to use that name.
Okay. So this segues really well into what are some of the misconceptions that businesses have about IP law? And basically, like you said, this is a long lawsuit, it's very expensive, and I'm a small company and I can't get involved in this or else I don't have a business anymore. What are some of the misconceptions, do they have a leg to stand on?
So I don't know about misconceptions, but I don't know how many small business owners really understand the value of registering the trademark with the U.S. Patent and Trademark Office, because what that does when you file an application, and you can file a trademark application before you even start using it. When you have a bona fide intent to use it in commerce, you can file it, and that puts everybody in the entire country on notice that you have the intent to use this trademark. So if you file a trademark application on an intent to use basis, and then after that time, somebody else pops up and starts using a confusingly similar trademark, you can actually stop them from doing that because you have the earlier filing date at the U.S. Patent and Trademark Office. So it's really valuable even before you launch your brand, to get the trademark application on file at the USPTO.
So that date's very important.
Yeah, because usually if there's no trademark application filed, trademark rights are governed in this country based on use. So if nobody has a registered trademark, you're in a dispute with somebody and neither party has a registered mark, the winner is going to be determined by who started using it first. And that may be you, that may not be you, so doing the diligence work ahead of time, making sure that the trademark is available and getting the application on file will really protect you from massive problems potentially down the road.
Okay. So let's say we have a business that's a little further along and they're starting to they want to generate new ideas. They want to generate maybe a new product, a new product line or something else. This falls into the wheelhouse very much of what I like to do is, help teams collaborate on their ideas, get the best ones forward so they know what to move forward with. When is an idea just an idea? And when is an idea a product or something you need to protect? Because sometimes you just generate ideas for the idea's sake, but now you want to start moving down the line. When do they need to start thinking about protecting that idea?
So for trademarks, especially if you're talking about launching a new brand or maybe a variation on your existing brand, doing, again, the trademark due diligence early to make sure that you don't choose something that's already taken by somebody else. That's a big deal. If you're talking about innovations on sort of like process or manufacturing or the end product even, again, getting an IP attorney involved to do the patent searching to see if there's anybody else out there that's already patented this idea, or maybe there's sort of a blue ocean situation. You can get a patent yourself on it. So looking at all that stuff early is ideal.
Okay. And what are some things that can't be patented? Like some people mistake that, I have this, I need to put a patent on it, but it's not really something you can patent.
Yeah. In the beverage industry, really the only issue that you're going to run into is what we call prior art. So what other people have done. There's this whole, when you file a patent application, what an examiner does is they go and they look at the date you filed your application and they compare what you invented, what you claim you invented, to everything that came before your filing date. So there's, there's all kinds of like public literature on, peer-reviewed studies that are published. There's a giant database of published patent applications and issued patents that they go look at. So there's a comparison between what you say you invented and all of that stuff that we call prior art. So that's the primary hurdle that you have to overcome if you want to get a patent, let's say, in the beverage industry. There are some other things, like you're talking about computer software or things like that. There are some other kind of specific hurdles that they run into. But yeah, it's mostly the question is what you're doing both new and not an obvious variation on what others have done before you?
Just starting to form that question, I was like, well, what do you do? And I mean, there's very few original ideas that aren't based off of something that's already happened. Just in the sciences, we're always standing on the shoulders of the ones that come before us to discover these new things. So how does all that incorporate versus, an original idea, that's easy guinea, but those are far and few between. So if I'm basing an idea based on somebody else's, even brewing is a couple thousand years old art. You can't patent that. So how does that work?
That's what I'm saying. I mean, patents are tough in the beverage industry just because it is so old, like you said. And I think it's more, a lot of the innovation comes more like on the sort of like the manufacturing side, how to do manufacturing more efficient, how to do the package better. How do you provide barrier properties on the package to keep the oxygen out? All that kind of stuff. But the beverage itself, it's going to be really tough to get a patent on that.
Okay. So the recipe that's not something you're going to be patenting, or the process?
Probably the recipe, probably not. There's just so much prior art out there. Yes. Unless you really, you came up with something that nobody's ever thought about.
Okay.
And maybe there is some sort of like ingredient out there that you include in the beverage, and it's, gives it, 10 times the shelf life or something like that. I don't know.
It has to be significant. Okay.
Yeah. But yeah, that's just going to be tough to do in the beverage industry. Like I said, I mean, every beverage company that I've represented, the brand is the most valuable part of the business.
Okay. All right. So that's something for all beverage owners, new and old, to keep in mind. So, yeah, okay. So I'm kind of trying to get not too much in the weeds here, but it's kind of fun. Yeah. Again, we talked about what can be patented, what can't be patented, and then branding and what was it, trademark are some of the key pieces.
Yeah.
Are there any other situations you've run into that are kind of exceptions to the rule?
No, it's most of the disputes that I've been involved in have been trademark branding disputes. Those are kind of the same things in my world.
Same things. Okay.
Yeah. So like recently, a client of ours had to file a trademark infringement lawsuit against a competitor over a whiskey brand. We filed it in the District of Colorado federal court, and my client owns a trademark on Lasso Motel for whiskey. And, a competitor launched a brand called Lasso Whiskey. So even though the trademark is not identical, that's not the standard. The standard is whether the infringing mark is confusingly similar. And my client believed that consumers were likely to be confused when you have two brands sitting on the shelf next to each other. One says Lasso Motel and one says Lasso. I think the consumers would think that those two whiskey brands were coming from the same source. And that's really what a trademark is. It's a source identifier. And the reason we protect trademarks the way we do is to protect the consumer, so that when the consumer goes and picks up a can of Pepsi off the shelf, they know who made it. When they pick up a Lasso Motel whiskey, they know who made it. And then if they see one that's confusingly similar, they're thinking, well, is this made by the same guys or is this somebody else? That's really kind of the reasoning behind why we protect trademarks the way we do in this country.
Okay. So this not only protects the product, but it also maybe protects the success of both businesses in that case, because you could get so confused as a consumer that you just choose to go someplace else altogether.
Yeah, because if there's an issue with one of the two products, consumers could reach out to the wrong company and say, hey, this product was bad, this is expired, whatever it is. And I've run into that all the time in the trademark where, a client will call me and be like, we have consumers of our competitor sending us messages through our website saying that there's this problem with their product that we don't even sell. And so that's like a big trigger usually for this type of dispute.
Interesting. Okay. And this may apply a little bit more to the restaurant industry, but if there's a parallel, if you're taking something you do in your shop and you eventually want to move it over to, does that change anything IP wise? So the best analogy is if you're in a restaurant, you have a great dish and you want to now box it, make it shelf stable and put it in the grocery store. Does for like a CPG, does that change your IP?
It's a good question. That trademark might fall into a different international class for prepackaged food rather than maybe restaurant services. So you may need to do a little work there protecting the trademark in a different international class.
Okay.
But yeah, that may be tough. Tough to do though. Make it shelf stable and sell it though. And I guess unless you can get some freezer or some refrigerator space. I don't know.
Okay. So some things have changed. All right. I'm just kind of curious. I've talked to CPG before, and I was kind of curious on just the first time I dawned on me, oh yeah, IP and be pretty important in that situation. I just wondered if it changed from point A to point B once they decided to take it and turn it into a different product, but it's still the same thing. It's just the way they deliver it.
Yeah, I think with any CPG business, your brand is just super important. I mean, that's
okay.
B2B. Sometimes you have maybe a more sophisticated type of customer that takes a little bit more care in their purchasing decisions. But you got somebody just sort of like rolling through a grocery store, picking stuff off the shelf. They may not be taking quite the same amount of care as somebody who's like a B2B client or customer is going to take.
All right. So we've talked a lot about the importance of protecting your brand, and that's where a lot of the IP comes in, the trademarking. where does your brand have to be? At what point do you want to, I understand protecting like what you call it. Where should your brand be before you, or what do you need to know before you want to go out and put that umbrella over it? IP, like how solidified does it need to be?
Really, as soon as possible. I mean, I've got a client right now that's going through a rebranding process, and they hired, a marketing company to come up with some options, for it. And as soon as the branding company settled on like 3 or 4 good options, we started doing trademark searches to see which ones were available and which ones were not. So, because you don't want to invest a whole bunch of resources in, packaging, website, and all this kind of stuff, only to come and find out that somebody else is already using it or somebody else already registered the trademark. So that was super important. And we actually did find that there were existing marks on a couple of the options that the marketing company came up with.
Okay.
So, yeah, so it's just super important to be thinking about that at the very beginning.
And are there resources available for somebody to start searching on trademarks to make sure they're not copying or duplicating, or how's that?
Sure. Yeah, the USPTO actually, when I say that it's the U.S. Patent and Trademark Office, USPTO has a fairly intuitive trademark search feature, and you can find it. I can't remember the exact URL, but it starts out with search.uspto.gov, maybe something like that.
Okay.
And I mean, it's really easy to do like what we call a knockout search, and you can just type the exact word that you're thinking about into the search bar, and it does a pretty good job of pulling up, similar or identical marks that are already out there. So that's a good like first level that you don't even need an attorney for. You can tell pretty quick if somebody has your exact mark that you're thinking about using.
Okay, that's a great tip. Thank you for that. And we're speaking of tips. I may have already given it away, but what's one thing someone could do right now to improve or to take care of their intellectual property?
If you're using a trademark and you don't have a registration on that trademark, just do that. It's so cheap. The USPTO charges for a trademark application in one international class. The USPTO charges $250 right now. It's going up to $350 in January. So, and then, I usually charge a flat fee of $1,500 to prepare and file the application. So as legal costs go, I think it's pretty cheap to do.
Yeah.
And if you've got any sort of like a decent size beverage company, I think you can afford to file a trademark application on it. So that's like bare minimum.
Okay. And how's that differ from the fictitious declaration when you're starting a business?
You mean when you're like in corporate law, like when you file a fictitious name that's not a company name? I mean, that can be sort of like evidence that you're using the mark, but really the only way to get the benefits of a trademark registration is to file one.
Okay.
Yeah. And then you mentioned cannabis companies. You actually, the U.S. Patent and Trademark Office will not register trademarks related to cannabis products. So really your only option there is to register them in each individual state that you're using it in. And that's a little bit more time consuming, a little more costly, but it does give you some sort of protection over your brand. But right now, pretty much anything, if you're selling anything other than smokable hemp, which is, the cannabis flower with less than 0.3% THC, anything other than that, the USPTO will not let you register it. So you're stuck with kind of being protected by state law.
Okay. Seems like the real Wild West right now with that particular product.
Yes. But you can still do a decent job under state law protecting it.
Okay, great. That was good to know.
It's really mostly legal only in, 28 states or something like that. So you're not really probably going to be operating nationwide.
All right.
Go ahead.
There's some, like I said, most of them aren't operating nationwide yet, but the laws keep on changing, and now they're able to at least bottle in a state and distribute to other states now. So that has changed.
Yeah, for maybe like hemp-derived cannabinoids, but even that, a lot of that's
exactly. We can have a whole other show on this. This would be great.
Yeah, it's especially if it's if it's hemp-derived THC, I think you're kind of rolling the dice there if you're doing that.
Okay. Personally. That's good to know. That's good to know for anybody listening who wants to get into this. I've interviewed one already. I'm going to be interviewing another. And it is really interesting to see the creativity that comes out of running these businesses.
Yeah. So there is, I've brainstormed ways to do it and stay in compliance with the law. As long as during like the entire process, you're keeping the level of THC below 0.3%, you might be able to do it.
Interesting.
But if at any point, like if you're like extracting THC from hemp and that extract has more than 0.3% THC, even if you're diluting it back down in a beverage to below 0.3%, I think your potential is there for problems.
Interesting.
If the federal government ever cared about it, they could maybe make your life miserable there.
Well, I figure even at one time, whiskey and bourbon went through some of this stuff coming out of prohibition and all that. So it's just another interesting story to follow and just follow the history of that.
Yeah, they're looking at rescheduling it too. So they may reschedule cannabis to Schedule 3, which makes it a little less risky, but it's still technically a violation of the Controlled Substances Act. So
interesting. Wow, it's just how they can do business around this is really neat.
Yeah.
So I got a couple more questions. This one's really fun. I have to ask everybody that is a guest on my show is, what is your favorite beverage?
Other than water, which really is my favorite beverage, I would have to say right now it's probably the IPAs that are made by a company called Outer Range Brewing in Frisco, Colorado.
Okay. Outer Range Brewing. All right.
Yeah. They're amazing. It's actually kind of like hard for me to drink an IPA that's not made by those guys.
Oh, wow. That's a lot.
So it's, you don't really see it too much outside the state of Colorado because they're a fairly small operation. But I think they just won like the, I don't know, USA Today named them like the best, après-ski brewery or something like that in the country. I can't remember exactly what it was.
Hopefully if you created a new destination for my listeners to go check out. That's awesome.
I mean, their beers are amazing, really.
Awesome. Great. All right. And also, finally, where can people find you? Do you do any shows, promotions, anything along those lines? Especially, we talked a lot about protecting your brand. We talked about some of the THC beverages, and where can people reach out and find you?
Definitely find me on LinkedIn. Just search my name. I'll be on there. I communicate with people on LinkedIn fairly regularly. And then, anyone can feel free to shoot me an email. I don't do a whole lot of like marketing other than that. So my email is just james@caglaw.com. So pretty easy. Happy to hear from anybody.
All right. We'll have all that information, your site, your LinkedIn, and email on our show notes as well. So if anybody is interested in reaching out to James and asking him some more IP questions that I didn't ask, feel free to reach out to him. And also, again, I want to thank you. Your push on brand and trademark, I've never thought of it that way. I just have always thinking just product, but it's much more than that. And just based around that is, I hope people listening, owners listening, start looking at that, especially new owners, like protect your trademark and your brand as fast as you can. Make sure you're not copying somebody else's. I'm sure if you do, that gets you in a lot more hot water and a lot more expenses down the road than you'd care to put into. So
much more expensive to fix it after the fact.
For sure. All right, Dave. I want to thank you for being on the show and sharing this valuable information. I again hope that anybody listening, beverage owners, industry owners, non-beverage owners, other business owners, understand the importance of this and will help spread the word. Thanks again for being on the show.
Yeah, thanks for having me.
Thank you for listening to Harvest to Pour, the business of beverages with Matthew Shipp. Check the show notes for our guest contact information and connect with Matthew Shipp on LinkedIn today.